Government Order of the Day number 5.
Civil Defence Emergency Management Amendment Bill, first reading.
The Honourable Amy Adams.
Mr Speaker, I move that the Civil Defence Emergency Management Amendment Bill be now read a first time. I nominate the Government Administration Committee to consider the bill. At the appropriate time, I intend to move that the bill be reported to the House by a date that is 6 months from the day the bill receives its first reading. This bill will amend the Civil Defence Emergency Management Act 2002. It will make a significant difference for communities across the country hit by our most frequent emergencies, those of small to moderate size, often created by the impact of floods, storms and natural hazards. This bill is about helping communities get back on their feet more quickly after an emergency. When there's an emergency, over time the focus switches from response to recovery, and we need to better manage that transition. Historically, most attention has been given to preparing for and responding to an event. However, as we've seen in the Manawatu-Whanganui region following the severe storm in June, the clean-up and recovery phase can involve a huge amount of work. The new law will give clarity to those leading this work and help ensure it can be carried out as swiftly and effectively as possible. It will do this by providing the appropriate authority for those directing, coordinating and managing the recovery. Strengthening the statutory framework for recovery from emergencies is one of the Minister's top priorities for the civil defence portfolio. By beefing up the legislative framework for recovery, we will help communities recover from small to moderate emergencies more quickly and in better shape. Recovery is defined in the bill as the coordinated efforts and processes used to bring about the immediate, medium-term and long-term holistic regeneration and enhancement of a community following an emergency. Recovery activities broadly mean those carried out under the Act or any civil defence emergency management plan after an emergency occurs, including the assessment and ongoing of monitoring of the needs of a community affected by the emergency, the coordination and integration of planning decisions, actions and resources, measures to support the regeneration, restoration and enhancement of communities across the 4 environments, being built, natural, social and economics, and for the cultural and physical well-being of individuals in their community, measures to enable community participation in recovery planning, and new measures to reduce risks from natural hazards and built resilience. In October, the Minister for Canterbury Earthquake Recovery introduced the Greater Christchurch Regeneration Bill. Whereas that bill needs to target a specific set of circumstances, the Civil Defence Emergency Management Amendment Bill needs to provide a flexible, adaptable and scalable framework applicable to the consequences of any future emergency. Mr Speaker, recovery needs to begin on day 1 of the response to an emergency, but it can be complex. It involves many parties, many resources and difficult decisions. With the current lack of legislative clout or provisions for recovery, we've been running a system that has often relied on goodwill and relationships to get things done. This bill creates a framework that will better support recovery management to ensure that it's timely, effective and focused. It provides authority and a stronger mandate for those directing, coordinating and managing recovery. The bill conforms to the core CDM principles of act locally, coordinate regionally, support nationally, which supports local devolution. It also includes better managing the transition once the response is dealt with, to move into a greater focus on recovery. It does this while ensuring a principled approach for use of extraordinary powers. Once the legislation is enacted, we will see a legislative mandate for recovery managers, a requirement to plan and prepare for recovery in advance of an emergency, and powers to support the transition into the initial recovery through the transition notice mechanism. The bill also establishes a permanent legislative authority for the government's financial assistance to local government for eligible response and recovery costs. I want to just briefly touch on some of the key features of the legislation. The first relates to recovery managers and planning for recovery. The bill establishes the role of National Recovery Manager and allows the Director, Civil Defence and Emergency Management to delegate certain functions and powers to the National Recovery Manager. It allows the National Recovery Manager to provide national and additional support to a Civil Defence Emergency Management Group if the recovery is beyond the capability and capacity of the group to manage and coordinate. It requires each Civil Defence Emergency Management Group to appoint a Group Recovery Manager and alternate persons for the role and establish powers of delegation for Group Recovery Managers. It enables a Civil Defence Emergency Management Group to appoint a local recovery manager at their discretion. It disestablishes the role of recovery coordinator provided for in the Act and requires Civil Defence Emergency Management Groups to prepare strategic recovery plans to complement those currently required in group plans. The next highlight is that the bill enables Civil Defence Emergency Management Groups to better transition from response to recovery. Currently, the response powers available under a state of emergency cease when a state of emergency ends. During the transition phase, after the response ends, diversion of resources to business as usual can threaten the ability to fully recover from an emergency. This is not just an issue of getting things done quickly. It may impair the ability to recover in the longer term or may destabilise what was achieved during the recovery. That transition phase is critical. The bill creates transition notices which will provide a defined subset of emergency powers to support the transition from response into focused recovery. There will be two types of transition notice, local and national. This is consistent with the principle of devolution to local authorities and offers the ability to appropriately and proportionately target the use of powers to a particular event. Just as a national state of emergency is very rare, the issue of a national transition notice is also likely to be very rare. A range of criteria will be taken into account when issuing a transition notice: the area affected by the emergency, whether the focus of activities is moving from response to recovery, including but not limited to if a state of emergency is about to be terminated, and whether it's reasonable and necessary in the public interest to invoke extraordinary powers to manage, coordinate and direct immediate recovery activities so as to ensure a timely and effective recovery in the long term. A local transition notice could also be put in place by a mayor or an elected representative of the local authority or a person of appropriate authority appointed in advance by the CDM group and chosen from group members. The Minister may also put in place a local transition notice where he or she considers one as necessary, but the local authority or Civil Defence Emergency Management Group has not issued one. The Minister of Civil Defence could also issue a national transition notice. This is consistent with the ability to issue a state of emergency declarations under the Act, but I also want to note that a Minister has never declared a state of local emergency under the Act, so I think it's unlikely the Minister would ever need to issue a local transition notice. Now, in some cases, emergencies would generate impacts of sufficient severity that the recovery may be very challenging initially, but the safety of public and property is not an immediate danger, and so no state of emergency might be declared. In these situations, the Minister of Civil Defence approval will be required before a local transition notice could be issued. The Minister will need to have regard to whether invoking the powers associated with a transition notice is in the public interest and is necessary or desirable to ensure a timely and effective recovery. These safeguards are in addition to the usual public notification requirements. A transition notice should only exist as long as it is necessary to carry out vital and immediate recovery activities that could not otherwise be achieved during the transition phase. The maximum duration for the notices would be 28 days for local and 90 days for national notices, respectively. The suite of proposed powers available under a transition notice in the bill has been adapted from those available during a state of emergency. But given the different demands of response and recovery, the powers are not as extensive. The powers would only be able to be used for the purpose of supporting recovery activities during the transition and must be proportionate and only exercised to the extent reasonably necessary for the public interest. Examples of situations where these powers would make a material difference to recovery include where recovery managers need to prevent people from entering land that has subsided or may be at risk, or to, for example, conserve limited fuel resources in an isolated community. The powers would have the ability to impinge on property rights, so they come with a range of proposed safeguards. Protections against the misuse of powers would be provided by the independence of the decision maker, the procedure to be followed, the test set out above, the right of judicial review and the availability of compensation. Another key aspect is compensation. The Act's current compensation sections have been extended in the bill to cover transition notice periods. Finally, the bill extends CDM's Act's liability sections to provide protection from liability for people who carry out activities in good faith during a transition notice period. Separate to the purely recovery-focused aspects of the bill also establishes permanent legislative authority for Crown reimbursement to local authorities for certain response and recovery activities. A permanent appropriation better recognises the Crown's commitment to reimburse eligible response and recovery costs, provided relevant long-standing criteria that the Cabinet has agreed to are met in claims that the local authorities submit. The appropriation would provide sufficient flexibility.
I'm sorry, the Minister's time has expired. I call Claire Curran.